Under Section 135, Order of Production and Examination of a Witness. Section 135 Evidence Act 1872 speaks about order of production and examination of witness. Primary, it's a lawyer privilege to determine the order in which the witness should be produced and examined. The order is to be decided by the party leading to his evidence. In civil and criminal procedure, Order 18 of the CPC and Chapter 18, 20, 21, 22 and 28 of the CPC deal with the manner of examination of a witness. In civil cases, the party who has the right to begin, that is, on whom the burden of proof lies, examines his witness first. And in criminal cases, the prosecution has to examine its witness. However, Section 135 gives the power to the court to command or order in which the witness may be produced. The witnesses should be examined one by one, and when a witness is being examined, other witnesses to be examined afterwards must not be allowed to remain in the courtroom. If a witness remains so, his examination cannot be refused. However, a note is to be made to the extent that he was present in the courtroom when another witness was being examined. In a case of Radhika Gupta versus Darshan Gupta, 11 Supreme Court cases 479 in 2005, it was held that in this case the husband wanted to give divorce to wife on the basis of mental illness. The High Court in this case held that the woman should give her examination in chief or affidavit and then cross-examination, and after that she can be allowed to give the medical examination. The Supreme Court observed in this case that she should be allowed to give evidence in the way that she wants. She may give medical evidence first and then she may give her oral evidence if so desires. Section 136, just to decide the admissibility of evidence. Section 136 of Evidence Act 1872 speak about the judge to decide as to admissibility of evidence. This section says that the judge have the power for the admissibility of evidence in the examination of a witness and also check the statement of the witnesses which is given by the witnesses during the examination of a witness, that is relevant or irrelevant. Scope of Section 136 of the Indian Evidence Act is very important, as the witnesses comes in the court with the relevant statement, because if the witness come in a court with the irrelevant statement, because if a witness comes in the court with the irrelevant statement, then the judge of the court not admitted that statement of the witnesses in the case, and due to this all the facts of the cases must be clear. This is also mentioned in the Section 5 of Indian Evidence Act. All facts of a case must be relevant. There are some rules of a Section 136 of Evidence Act. Rule number 1, if any fact proved in the case which is proposed by the party in evidence, then a judge may ask the party in what the alleged fact would be relevant or not. A judge will decide the fact must be relevant. If the evidence would not be relevant, then the judge would not allow the party from proving it as as because it would only waste the time of the court. In such condition, court may disallow the evidence. Rule number 2, if the party suggests the fact of the evidence which is proved in the court and also depend on another fact of the evidence, then the other fact must be proved before the evidence of the first fact is given. For example, a dying declaration. If a person wants to prove a dying declaration, then he must prove that the declarant is dead. Here, admission of the fact depend on the conditions. Rule number 3. Rule number 3 is exception of a rule number 1 and 2. If there is a relevancy of alleged fact is there which depend upon the proof of another alleged fact, in this condition, the judge may allow in his discretion the first fact to be proved without proof of the second fact. But in this condition, the party must undertake to prove the second fact to the satisfaction of the court. As above rules, the question of admission of witnesses in a witnesses is to be decided by the judge. First, he invested all evidence with wide discretion, then allow evidence to be placed on a record. Under Section 137, Examination Chief. Section 137 of Indian Evidence Act 1872 defines the term examination in chief. When the party calls a witness in an examination of witnesses, that is called examination in chief. Examination in chief is a first examination of a witness after the oath. It is the state in which the party called witness for examining him in a chief for the purpose of eliciting from the witnesses all the material facts within his knowledge which tend to prove the party's case. It is also as a direct examination. There would be general questions asked in an examination in chief, which is related to the facts of the evidence. No leading questions are asked in an examination in chief. Leading questions are asked only in a cross-examination and re-examination. First of all, the prosecutor asks the question, is the question in chief is a criminal trial? The following are the objectives of an examination in chief. It overthrows the burden of proof legally sufficient. Remember and understand. Persuasive. Hold the cross-examination. And contradictory and anticipatory of evidence that the opposition will present. In a criminal trial instituted by the state, the examination in chief is conducted by the learned public prosecutor or the learned special public prosecutor, as the case may be, who is to establish the case by asking questions from the witness and permitting the witness to answer the same. Under Section 138, Order of Examination. Section 138 of Evidence Act 1872 speaks about order of examination. This section says that the first of all witnesses shall be examined in examination in chief, afterward cross-examination by the opposite party, if the opposite party desires, and at last re-examination by the first party, if the first party calling the witness for re-examination. All the examination of witnesses must relate to the relevant fact, but cross-examination no need to be controlled to the facts to which the witnesses examine on his examination in chief. This section provides a wide scope for the cross-examination. This section also says that the explanation about matters referred to in a cross-examination shall be directed by the re-examination, and if new matter introduced in the re-examination with the permission of the court, the opposite party may further cross-examine the matter. The following important points may be noted. In a cross-examination can extend to all the relevant facts, whether touched in the examination chip or not. A witness cannot be thrown open to cross-examination unless he is first examined in chief. The case where the prosecution did not examine its witness and offered him to cross-examine, then this amounts to abandoning one's own witness. Such approach seriously affected the credibility of the prosecution case. When a fact is stated in a cross-examination and there is no cross-examination on a point, naturally it leads to the inference that the other party accepts the truth of the statement. But there are several exceptions to this rule. These are where the witness had noticed beforehand, where the story itself is of an incredible or romantic character, where the non-cross-examination is from the motive of the delicacy, where counsel indicates that he is not cross-examining to save the time, and where several witnesses are examined on the same point. All need not be cross-examined. A cross-examination follows upon the examination chief unless the court for some reason postpones it. The court may permit the person who calls a witness to cross-examine him under some circumstances. If a witness, after being examined in a chief, does not appear to subject him to cross-examination, his evidence becomes valueless. Co-defendant in a case can be cross-examined by another co-defendant when their interests are adverse to each other. The proper limit of re-examination is to confine it to an explanation of the matter dealt with in a cross-examination. If a re-examination introduces new matter, the adverse party will have the right to cross-examine the witness over the new matter. An order of re-examination can be made by the court on an application by a party. It is not restricted to the court's own motion.